City of Orders. Section 1100.
Hmm. I'm just reading the operating portion of the judgment. In the present case, the accused petitioner was arrested on 27/2023, and therefore the decision of the apex court in the case of Pankaj Bansal Supra is not applicable. Hence, the arrest of the accused petitioner cannot be held to be illegal. Viewed thus, I'm of the unhesitant view that in the facts of the present case, Article 22(1) of the Constitution of India has been sufficiently complied. That being so, no violation of Article 22(1) is made out in the instant case. I cannot be unmindful of the seriousness of the nature of the allegations against the accused petitioner in the case in hand, the severity of punishment in case of conviction against the alleged offense, and also the fact that cognizance is yet to be taken by the trial court. That apart, it appears that the victims as well as the witnesses have implicated the accused petitioner for the alleged offense, and that one of the victims, whose father and brother are alleged to have been murdered by the accused petitioner, has also identified the accused petitioner to be one of the perpetrators. Thus, there are prima facie materials available on record indicating the involvement of the accused petitioner in the offense of promoting enmity, murder, assault, or criminal force to women with intent to outrage her modesty, rape, gang rape with common intention. I also cannot disregard the fact that the victims are yet to depose before the trial court. Furthermore, the apprehension of the prosecution that there is every possibility of the accused petitioner threatening and tampering with the victims and witnesses if is released on bail can also not be disregarded by this court in the peculiarity of the facts and circumstances of the case. There is no quarrel to the proposition that at the stage of granting bail, this court is not punishing the accused. It is well settled that grant or refusal of bail is the discretion of the court, and the same should be exercised judicially. I am reminded of the age-old principle propounded by the apex court in the case of Gurbaksh Singh versus State of Punjab, reported in AI 1980 Supreme Court 1632, that grant of bail is the rule and refusal is the exception. However, in the backdrop of the rare facts and circumstances of the instant case, I shall not be justified if I do not make an exception to the said rule. Thus, keeping in mind, amongst other circumstances of the case, the seriousness of the offenses, the prima facie case against the accused petitioner, the possibility of the accused petitioner threatening and tempering the victims and witnesses, and the larger interest of the public vis-a-vis Article 22(1) of the Constitution of India, I am of the firm opinion that bail at this stage cannot be granted to the accused petitioner. Accordingly, the prayer for grant of bail stands rejected. Here is a small correction yesterday. It is needless to clarify that the observation made in course of consideration of the bail shall not have any bearing on the independent judicial discretion of the trial court. Resultantly, the bail application stands dismissed. Return case diary and original records of the trial court. Original records of the trial court, isn't it? That is. Certified copy of the remand order as placed by MS M. Kumari, Learned Retainer Counsel, CBI, is kept on record and marked as X to mark credible. Sorry, Mr. Shekhar. Mr. Ahmed is not there. Rejected. You please inform. Article 21. Yes, Mr. Bora?
Out of turn, Millard, I have to mention before this Lordship. The reason being this, your Lordship has.
I'm not been assigned of any bench today.
Yes,
I have just.
Yes, but out of turn, why I have to, because of the notification which has been published by this Honorable Court on 3rd of May regarding the bail applications, Millard. What is
Only if I'm assigned to a criminal bench. I'm not assigned today, Mr. Bora. Please take it up with the registry. They'll do what is to be done.
because no,
All right, Mr. Bora.
Uh,
Please take it with the registry. They will do it.
because the same of the error.
All right.
It has to be placed either on the, if your lordship is in outside the state, my lord, through.
Only if this bench is taking up a criminal bench. So
But no,
you
the
take
same-
take up with the registry.
But the same FIR, my lord, has to be go to before the same judge.
No. Same judge, provided that judge is taking up criminal matters. You please have a look at that
My lord,
memorandum. You take it before the registry.
Well-
Registry will do the needful.
my lord.
Ms. Kumari, if you, you can just go through the judgment once. If there is any correction, Mr. Shekhar, just have a look at it. If any correction, you can just inform because two cases were there sometime while recording the facts. So just have a look at it. Feel free to just point it out. Huh?
Right.